Dear President, dear Ambassador, distinguished members of GREVIO, fellow judges of the European Court, ladies and gentlemen, it is a real pleasure to deliver the opening address at this joint conference, conceived as an academic dialogue between our court and you, the group of experts on action against violence against women and domestic violence. You have chosen as your theme the converging impact of the European Convention on Human Rights and the Istanbul Convention. I would like to thank very warmly today's organizers, and in particular Vice President Jelic, my dear colleague Ivana, who has worked tirelessly to ensure such a rich program. And just I want to say also that the presence of so many judges in the room is meaningful. It shows how important it is for our court your commitment in this shared field of fight against any form of violence against women. This conference is one of the number of events organized to celebrate the 75th anniversary of the European Convention on Human Rights. This birthday invites us not only to reflect on the Convention's achievements, but also on the challenges that remain. And one of those challenges is the persistent reality of gender-based violence, the most shameful human rights violation and perhaps the most pervasive, to quote former Secretary General of United Nations Kofi Annan. Indeed, it is present in every member state of the Council of Europe, in every society of the world. It constitutes one of the most striking manifestations of inequality between men and women. From harassment in the street to feminicide, from symbolic humiliation to physical assault, violence against women exists along a continuum that no society can afford to ignore. Opened for signature in 1950, the Convention was deliberately drafted in broad, inclusive terms. The drafters chose not to produce a detailed catalogue of rights and obligations, but instead a text that could stand the test of time, capable of evolving with society and serving as a true living instrument. The Court has remained faithful to that vision. As the preamble itself proclaims, the Convention is dedicated not only to the maintenance, but also the further realization of human rights. Through its dynamic and evolutive interpretation as a living instrument, the Court has ensured that the Convention speaks to realities that were unforeseeable and even unimaginable at the time it was adopted, including issues related to new technologies, bioethics, and climate change. It is precisely in order to confront such emerging issues from a human rights perspective that the Court strives to keep the Convention alive as a living instrument, while ensuring that its intervention remains legitimate and within the limits of its judicial role. The metaphor of living instrument resonates with another interpretative tradition derived from a case of the Supreme Court of Canada, the living tree doctrine. Of course, evolutive interpretation is not without limits. Judges cannot become legislators. They cannot invent new rights and thereby transform the Convention from a living tree to a moving tree. They cannot go further in that judicial interpretative power than to harvest the fruit from the tree planted by the framers. Only sovereign states, parties to the Convention, have legitimacy to create new rights. Indeed, the Convention has over the years been supplemented by various additional protocols ratified by the member states themselves, which have expanded the catalogue of substantive and procedural rights. For much of the history, gender-based violence was treated as a private matter, behind closed doors, a cultural issue, or worse, an inevitability. Only in recent decades had the international community begun to systematically recognize it for what it truly is, a violation of human rights inflicted precisely because the victims are women. And the court has played an important role in this process. In 2009, in the landmark judgment of Puss versus Turkey, it for the first time recognized that domestic violence disproportionately affects women and therefore constitutes a form of gender-based discrimination. This recognition was transformative. It obliged states to prevent such violence, protect victims, prosecute perpetrators, and promote the cultural change that genuine equality demands. From Opus onwards, the court has developed a rich jurisprudence addressing gender-based violence under multiple provisions of the Convention. It has clarified that states have also positive obligations to prevent, investigate, and punish acts of gender-based violence, and by doing so, to protect those at risk. The Istanbul Convention, adopted in 2011, is deeply entrenched in the court's case law and profoundly inspired by it. Its explanatory report acknowledged this. And this illustrates another dimension of the convention system. This treaty is not only a living instrument, but also a matrix that inspires the development of new international norms. To extend the tree metaphor, it is a living tree that not only bears fruit, but also sows seeds from which other trees may grow. The Istanbul Convention was the expression of the sovereign will of the states to codify, consolidate, and operationalize the court's case law, which significantly reinforced its legitimacy. But the states went further. By ratifying the Istanbul Convention, they conscientiously chose to expand the reach of the court jurisprudence and created the most comprehensive international legal framework to combat violence against women. And they also established GREVIO, your group, this so important and, if I may, vital monitoring mechanism. The relationship between the two conventions, one general and the other specialized, is not linear but reciprocal. Since its entry into force, the Istanbul Convention has become a gold standard in combating gender-based violence. It has also been a source of legitimacy for the court and a source of inspiration in its work on combating all forms of violence. The court, for the first time, referred to it in 2016 in the case MG versus Turkey. Since then, it has increasingly drawn upon its provisions and the invariable experts' reports of GREVIO, and it allows the court to reinforce its interpretation of the European Convention. As my predecessor, President Schieffer-Valéry, noted, I quote, "It has to think of another Council of Europe's Convention or monitoring body which figures as frequently in our judgments." For its part, GREVIO frequently references the court's case law in the reports. And this interactive communication between what you did in your report and what we take on board in our judgment, and what we stated in our judgment, and what inspired you in your report, which is the most fruitful way of working together for the same goal. In HW versus France, a case from this year, which concerned the notion of so-called conjugal duties, the court used the Istanbul Convention to reinforce its finding that marriage can never imply consent to sexual relations. And PP versus Italy, again from this year, GREVIO's concerns about excessive delays in criminal proceedings and systemic failures were echoed in the court's finding of a violation of Article 3. In Yehu versus Moldova from 2024, the court heavily relied on GREVIO's evaluation report finding a violation of Article 3, criticizing the authorities' failure to recognize psychological violence and to act diligently. In Asmik Khachaturian versus Armenia, also from 2024, it used GREVIO's findings to condemn the systemic failure to impose deterrent sentences on perpetrators of domestic violence. And I could just add more and more judgments which show how important are your materials for our judicial adjudication. The court draws on the Istanbul Convention not only, and this is important to underline that, when the states have ratified it, but also, in any event, as a source of inspiration and interpretative legitimacy when they have not. This reflects the Istanbul Convention normative weight and influence. For example, in the case ND versus Switzerland, which concerned abduction and ill treatment of the applicant by her partner, who also tried to kill her, the court did not base its reasoning directly on the Istanbul Convention, which at the time of the events had not yet been in force in respect of Switzerland. It nonetheless took that convention into account as a part of the broader international framework guiding its interpretation of the convention. In AE versus Bulgaria, in which the applicant, a 15-year-old girl, complained of severe domestic abuse by a much older partner and of the authorities' failure to protect her, the court found Bulgaria's refusal to ratify the Istanbul Convention indicative of that state's commitment to fighting domestic violence. These examples show that the two conventions are deeply connected and complementary, reinforcing each other in a dynamic and reciprocal relationship of cross-fertilization. This fruitful dialogue between the court and GREVIO illustrates this complementary. GREVIO contributes expertise and comparative insights, while the court provides binding judgments. Together, we ensure coherence, avoid fragmentation, and reinforce the fight against women through a shared methodology, strengthening the protection of women across Europe. This conference is a testament to that powerful and necessary energy. In recent years, victims of gender-based violence are increasingly turning to courts in search of justice. The highly publicized Mazan trial in France, made exceptional by Madame Pellico's extremely courageous decision to hold it in public and resulting in numerous rape convictions and lengthy sentences, stands as a powerful example of this growing trend. This trend creates, if I may, a virtuous circle. The more the judiciary addresses gender-based violence, the more it refines and develops its case law on the matter, which in turn encourages victims to step forward and bring more cases before it. The court's docket has also seen a rise in number of applications concerning violence against women, enabling it to expand its jurisprudence to cover the full spectrum of such violence. 3 terms stand out: consent, secondary victimization, and intersectionality. I will now address each one in turn. As regards consent, the court has repeatedly affirmed that it must be free, informed, given at the time of the act, and can never be assumed. In cases from the Czech Republic and France, the court has condemned failures to assess consent properly, especially in situations of vulnerability. I have already mentioned the case of HW versus France, which centered on the national law which established fault-based divorce for failure to fulfill conjugal duties. The court held, and I quote, that such concept of conjugal duties took no account of consent to sexual relations, and that any non-consensual act of a sexual nature constituted a form of sexual violence which states had an obligation to prevent both under European Convention and Istanbul Convention. In another French case, L and others versus France, a case concerning non-consensual sexual acts against minors, the court condemned the shortcomings of the criminal law system in properly establishing consent. It stressed the duty to take account of the vulnerability of victims and importance of analyzing all the surrounding circumstances of each case. It explicitly held that states' positive obligations under the European Convention to protect individuals from non-consensual sexual must be interpreted in the light of the Istanbul Convention. And this obligation to take on board the surrounding circumstances directly derives from GREVIO expertise and recommendation. And from now on, it is part of the court's case law. The court further warned that any rigid approach to prosecuting sexual offences, such as requiring proof of this physical resistance in all cases, risks creating impunity for certain forms of rape and undermining the effective protection of sexual autonomy. Yet, while French case law often considers the absence of consent, the French Criminal Code contained no explicit reference to it. This regulatory gap was also underscored by GREVIO in its recent thematic evaluation report, which was published just a few days ago, and which urged France to adopt a definition of sexual violence firmly grounded in the absence of the victim's free and informed consent. And as you know, there is a pending draft before the French Parliament, which proposed to change the definition of rape, taking on board not only the GREVIO's recommendation, but also the most recent state of the court's case law. And it shows how important it is for our two bodies to maintain the system under pressure for the best of the protection of women. The issue of consent arose again in the most recent case of EA versus France, a lot of French cases, in which the court had to assess whether the applicant freely consented to certain violent sexual practices later inflicted on her. It held that, in assessing the applicant's consent, given in the form of a contract, a written contract, the domestic courts had overlooked the coercive control exerted by the perpetrator in her professional and private life, and her deteriorating mental health. The court also stressed that consent must be freely given at the moment of the act and is always revocable. No past agreement, not even a written contract, can establish present consent. In other cases, GL versus Italy, X versus Greece, but also L and others, and EA versus France, the court emphasized that judicial proceedings themselves must not become a source of new trauma. And this is my second point as regards secondary victimization. Specifically, in GL versus Italy, the court criticized stereotypes and led to the secondary victimization of a gang rape victim and to violation of her right to private life. It stated that judges must, and I quote, avoid perpetuating sexist stereotypes in judicial decisions, minimizing gender-based violence, and prevent the secondary victimization of women through guilt-inducing or moralizing language, which could undermine victims' confidence in the justice systems. Perhaps most critically, the court case law has evolved to grasp the complex reality of intersectional discriminations, and it will be my third point. IC versus Republic of Moldova concerned a woman with an intellectual disability who claimed that the investigation into her allegations of labor exploitation, rape, and sexual abuse had not been effective, and this was due to the stigma attached to women with intellectual disabilities. The court found multiple violations of the European Convention and stressed the compounded discrimination she faced. This judgment demonstrates the court's awareness that violence cannot be understood in isolation from other axes of inequality, and that intersectionality is not longer only an academic concept. The growing judicial focus on violence against women has sometimes provoked backlash. A troubling resurgence of populist rhetoric, often amplified online, dismisses gender equality and promotes a return to traditional values and distorted notion of masculinity. And we have to keep it in mind. Our involvement and commitment in this necessity to fight against violence against women has to tackle with this new rhetoric. And this is really concerning. We must stand firm against such narratives which undermine equality. Those narratives reveal that law alone is not enough. Neither the European Convention nor the Istanbul Convention can by themselves eradicate violence against women. What is required is a profound societal transformation. The unwritten laws of gender inequality that permeate social interactions must change. The law can support this radical cultural change, but the strong commitment of each and every one of us is required to achieve it. In 1950, Europe's leaders launched a bold project to safeguard the dignity of every human being. 75 years later, the European Convention on Human Rights continues to speak with a living voice, reminding us to carry that vision forward to all. The Istanbul Convention, its younger but inseparable companion, has given that voice a new strength in the struggle against gender-based violence. Their convergence, reinforced by the cooperation between the Court and GREVIO, is essential for building Europe, where all women can live free from violence and inequality, and enjoy rights that are not theoretical or illusory, but practical and effective. We are gathered today to celebrate our common achievements and to deepen our dialogue. Let this conference serve as a platform for reflection, for the exchange of knowledge, for the identification of challenges, and for the strengthening of our collaboration. Above all, let it nourish our optimism for the future. Thank you.